nothing left. And when I looked at judgment, the brother judge complimented me. He said, "You have become a criminal judge." So what he meant was that you mastered criminal law. And this in the background, when the gospel changed, again I'm repeating, grow, make a mark for themselves, so the sky being the limit to them. See, that weekend when the pastor came, my uncle, I'm a judge, he rang me up. We began conversation. He said that, what are you doing these days? So I said, criminal appeal. That was what I was going to start on Monday. And he said, very good. So I said, what very good? I said, really. What he said was, why is a criminal lawyer himself? He said, why criminal lawyers? My grandfather was criminal lawyers. Yeah. So I have told him that the blood has become thick. Anyway, I was able to work on it, and one more thing. When I say the evidence, and in today's world, before we come to the new laws, forensic evidence is becoming very important. In another case in the Supreme Court, where the prosecutors for the minor went hostile, her mother went hostile, I said to myself, I told my brother judge, I was the junior judge on the bench, and I told my brother judge that no, I think this was good. Then again, later on, I said, send me the draft, then we discuss. We convicted that person on the same evidence, but on different grounds, from the forensic evidence available, which was not noticed by him. Right? This is the reason why some judges are considered liberal, some judges are considered conservative. The difficulty is, the judges of the High Court and the sister judges, pardon me, but this is a fact, that there is a lack of standardized approach. And this is not something unique to us. The difficulty lies there. I was reading a book by an American judge called, he gave it to me soon after my elevation in 2004. And the title of the book was How Judges Think. The reaction was, it looks like judges all over the world have the same problem. Because I'm not addressing the judges, I'm addressing the bar, I'm not addressing the kids. But that is something that is there, which we have to do. I mean, the bar assist the judge. How good the judgment will be depends on how good the assistance given to the judges. If you think the evidence is there and this is the judge, let the judge back his or her own ways to find out what is to be done. That is not the way. And don't get this. Most questions, what is the wage? In fact, that is the best way a judge resolves all the conflicts in his or her mind and the evidence. So, according to me, that is the fact of the possibility was. The more the questions the judge, the more the clarity the judges have, the better the judgment. And that is the way to be prepared. More straight, see the case and then prepare. Then ready and able to answer all the queries of the judge. I'll give you another example. Yes. Again, it because of this lack of this and these things are happening at this level. So see where we know it's the conviction was peace. And before I begin, yes, I have found consistent difficulty in appreciating the preparation and presentation of criminal cases barring exceptions. A criminal case requires very, very deep preparation. This consists of ambiguity. He had taken a plea of temporary insanity or during the speakers. He had published medical grounds for temporary insanity. The number of evidence is there as to what transpired immediately after the assault vis-a-vis the accused. Nobody knows. Even it is the basic duty of the lawyers. Now, again, I think it was the destiny of the litigant that we heard this case the other days. One line of the evidence, I think was distinguished. We were some straight to the Supreme Court. So I got from the original record, I found that the IO was in London. I didn't know anything. When my wife is Marathi, I asked her to read it slowly and explain to me. And when I was looking for I could. The person automatically. Because the evidence, the idea of establishing that evidence. See, these are where the flaws become small pieces which are overlooked. I start checking the videos. I think my pet theory was I was very actively involved in the Judicial Academy, which was regularly the Judicial Academy also. The pet theory was that crime is becoming smart, which means criminals are becoming smarter. They know how to cover their trap. They know how to commit offenses in a non-traditional manner. So if the crime is getting smart, the police has to get smarter. And the judge has to get the smartest. But it's very easy to say that it's not the judge who becomes the smartest. The judge becomes the smartest. The judge, of course, very the judicial academy, etc., all that is there. But the judge has to be helped to become the smartest. Because the lawyer helps the judge in dispensation of justice. Justice is not dispensed by the judge alone. As I said a little earlier, how good of judgment will be depends on how good the assistance is. Therefore, our role becomes very important in ensuring that justice is done in a criminal matter. Because take a small thing like witness protection scheme. It's a far cry. It's a far cry, yes. There are times when cases are, how can I say, I won't say lawyers, clients play games. And the royal authority also was yet. Remember one thing, you have a greater responsibility to the institution than to your client. In terms of encouraging dispensation of justice. And as I said earlier, one case will not decide your future. I was very happy to learn that here in the High Court, Justice has taken up the issue of framing new laws. Because it is basically, of course, there's one theory that these changes have come up because it was basically laws made by the British, which were colonial in nature and which were meant to serve the interests of the British. I don't know which aspect that is not our footprint being on the legal field. I will follow on the theory that the passage of times, with new types of crime developing, with new tools of investigation being available, with the past experience of the flaws in the criminal law system, the legislature thought it necessary that this matter needs to be looked into and something needs to be done. Because truly speaking, things you are getting very alarming in the field of criminal law. How the committee was set up and the report came, and we are all aware of it. It's going slightly different take on this issue. That I think what the Chief Justice said makes a lot of sense. What High Court would do that? Training lawyers also. I've always believed that lawyers need to be trained. Because for their being successful, the lawyers will have to be trained, the judges will have to be trained, the police will have to be. And it is my personal belief, based on my own experience as a judge, both as a new judge at Patna, where I watched the whole thing with great amusement 2 years after my elevation. Till I implemented the idea that the Chief Justice of Chhattisgarh, we organized a joint conference with the police and the judges, the trial court judges and the police. And Justice Koshi is there. He will be able to better tell you what the effect of it was. All I told the judges and the police officers was that say anything you want, speak anything you want, point any information. I believe that it was a great success because the judge can't do anything alone, the police can't do anything alone. They have to work in tandem to make sure that justice is dispensed. One thing I would like to point out to the younger generation, many of you may be going to criminal courts also for trials. The art of cross-examination has taken a very bad beating. Today we have come across cases where, because of wrong questions being asked in cross-examination, getting answers which should never have come on the record, which leads to the prosecution case falling or the defense of the accused collapse. So cross-examination is also an art which you will have to develop by expanding your own knowledge, by reading judgments, sitting and watching trials, reading textbooks. In other words, to put it very simply, you have to grow as a learner. And for the younger members of the bar, then I'll come straight to the new three laws. Keep one thing in mind yourself. You have to create an image about it. In other words, You should be ready with your brief. You should be a lot to the extent you can. Do your research, do your homework. Never try to mislead the court or make an erroneous submission. If you make an erroneous submission, own it up immediately. Because to build up your career, very essential is you build an image of yourself. When you stand up before a judge, the judge should be able to say to himself or herself, oh, this guy, he can be dependent. Half your work is done there. The new laws is taking place on the three of them. A lot of say, I will not go into the numbers. IPC and the new Bharatiya Nyaya Sinha, the number of sections is reduced considerably. Then in the old CRPC also it has reduced. The Evidence Act has gone up. These three laws, the intent to do is take note of the different patterns of crime which is coming up and recognize them as separate offences. Earlier, they were being interpreted as falling within one provision to the other provision. For example, section 69 of the new penal code, it provides that the sexual harassment takes place by deceptive means, deceptive commitments, the word theory. Regarding job advancement, this is very specific. Inducements for a job, marriage concealing from the identity. And this all was given right to a lot of civil litigation. What is coming specifically for the criminal offenses. Earlier, crime was taking place, but the idea of criminal syndicates, organized crime, has come and has become a big problem. Another section, 109, recognizes it specifically. Unlawful Prevention Activities Act. That is being brought into in section 111, and it covers the whole gamut of issues. Terrorism doesn't mean this again has to be a part of the training to the police and the terrorists. It covers the gamut. How to implement the gamut. Of course, sedition law was changed in section 150. Here, what the British had done was given it a very narrow interpretation. Permits freedom of speech, but then where the unity and integrity of the country is concerned, or subversive activities that is, it does not allow. Then what we have today is electronic means. It's creating a lot of problems. Certain kinds of injustice, humiliations, character assassination is being done through electronic means. That has specifically in section 179 of the EU law. There are situations where in lawful exercise of power, somebody is arrested, somebody is being asked to disclose something, the person goes and commits suicide. Tries to commit suicide. That has been made a separate case. Those of the elder generation, lawyers, criminal lawyers will recollect the Vasanti case, which originated from Bihar, which laid down the law, Supreme Court laid down the law with regard to appreciation of evidence where there is a mass scale crime committee. That has led to the incorporation of section 101, where a crime is committed, acting together based on the race, caste, sex, or place of birth. Then 302, snatching cases in appropriate situations will come under it. This is a completely new development because snatching is certainly a crime which is assumed alarming proportions. Then for offences against minor girls below the age of 18, death penalty has been introduced. Then, as Chief Justice Radha pointed out, the new the new Evidence Act, it recognizes all the act was the Information Technology Act, with its triggers under section 65 as to when it can be accepted. There is a big cloud over it, it recognizes electric records, electronic records as primary evidence. It allows electronic presentation of documents, permitting remote accessibility. In this, imagine the kind of difficulties that are taking place where the witness is living in our country, another state, and the file that is then, as was pointed out to you, that one of the accused absconds. The trials used to get separated, the others met up with, the accused who absconded, his trial is conducted separately. At times it reached a different conclusion. So one was last said was that once it was convicted. Now, in this, I remember perhaps this is an outcome of judgment of the Supreme Court. Because I remember having used a judgment like this in a large number of occasions where an accused, having got bail and appeal, was absconded. The others were present, one was absent. So perhaps the legislature will conclude from there the judicial pronouncements. These courts found a way out of it. It's creating a very enormous situation. Gets acquitted, and the other convicted on basis of the same areas and evidence. Then secondary documents from 1st of July in order to written admissions. The testimony of a person was examined the document and the skill in the examination process. Perhaps the most important change is the new RPN that is the CRPC. It mandates for in section 176 forensic investigation of crimes punished with 7 years imprisonment or more. The to visit and gather documents and evidence. Now, what my theory always was, and what I really strongly believe, that the ground for conviction or acquittal in a crime takes place, is laid the moment the police reaches the system. That is the first opportunity when relevant evidence is available, it is either preserved or destroyed. If it is destroyed, the best of cases can end up with wrong results. This takes care of that and puts a mandatory application. The forensic evidence, I would suggest the younger generation of lawyers to acquaint themselves. Training programs being conducted with regard to forensic evidence, and forensic evidence is not confined strictly only to offences against the human body. It can be economic, it can be social, it can be various aspects. specified situations, after serving half the maximum imprisonment, the accused would get released on a personal bond, except for death penalty cases. Now, under the new CRPC, this will not apply to any offence where life imprisonment or an individual is punished for more than 12 months. Again, a basic change takes place with regard to medical examination in cases of sexual clear. It was conducted by a medical practitioner on the request of the substance. But now it is expanded that any police officer can make a request to the medical officer to conduct a medical test. Then we all very well acquainted with zero FIR. It has now been given as an application. I don't need to discuss what zero FIR is without acquittal. Then Selby says it is about self-incrimination, etc., which later on the law. Now, this legislation, I don't know, it will be very interesting. Section 349, it authorizes the magistrate to order specific signatures of handwriting and to include finger impressions and voice, even from someone not arrested. I don't know, this will probably end up in the courts. Of course, there are deadlines for filing charge sheets, for examination, for completion of arguments, delivering judgment. So my current hope will be when we give it with changing times, the courts will give it a where even the police will have to understand the implications of not doing. Because you see, it's correct. Other age deals with open statements. That originally fixed a time limit, we diluted it. The legislature, I don't think it intended that by paying costs, you can delay it beyond that. But we did. So I hope that in this time it doesn't come across because, as I said, liberal judges, conservative judges. So let us hope for the best. Then we had Supreme Court judgments where handcuffing is held to be bad, not to be allowed. Imagine. Specifies habitual offenders escaped from custody, individuals accused of serious offences such as sexual assault, acid attack, organized crime, economic crime. Most important. See, in criminal trials is the big problem that the medical officer, the investigating officer gets transferred. We initially has tried all kinds of things. We tried it in Patna to build up a database, and we requested the police and the medical department to keep updating it. So my judge would go to the website, get the details of 16. And like all good things must come to an end. Now this legally recognizes that the successive officer can be closed so that the case can get expedited. So hope that things start changing, because I remember one incident when in 2009, 161 CRPC introduced video conferencing. Google 161 state. And we had a conference where I spoke about that the police has given cameras to all police stations. So my reaction was that a police officer is trained in a different manner. He has his own style of talking. Now we know what he will, how he will handle the witness also. He will tell the witness, you better be careful for what he is doing. In his own harsh tone. Tell him that you have to be camera, you have been filmed, if say anything false, you will end up behind bars and all kinds of things. So what happens? Witness speaks the truth. What we say in Hindi, police वाले ने Instagram पर लिखवा दिया. So good evidence comes in court. The judge will see that the witness looks scared. Well, it's on film, and film in accordance with procedure. The judge is thinking very rightly, he will reject good evidence. Said in the beginning, it has to be a cooperative effort to ensure that any changes in the law come forward. And I think the interpretation of the new laws, a lot will depend on the younger judges, the lawyers. Young, you've got new ideas, new thinking. You present your interpretations to it. You correlate it to the present times. You are better tech savvy. You have to use all your facilities at your command to help this water flow. Thank you very much.
Good evening, all. I, Navin, the First Secretary of Judicial. On behalf of Telangana High Court Advocates Association, I deem it a privilege to propose vote of thanks. I thank Hon'ble Sri Justice Navin Sinha Garu, former Judge Supreme Court of India, for accepting our invitation and addressing the bar. I thank Honorable Chief Justice Sri Alok Aradhe Garu for accepting General Sri A. Reddy Garu. I thank Additional Advocate General Sri Muhammad Imran Khan Garu. I thank Additional Advocate General Sri Tera Rajikan Reddy Garu. I thank Additional Solicitor General of India Sri Sharma Garu. I thank Public Prosecutor Sri Palle Nageshwar Garu and all other his staff. I thank Chairman, Vice Chairman, and Bar Council of India, and all the legal fraternity for attending this occasion. Thank you, one and all, for gracing the occasion and making it a great success. This is our education series for this academic year. This is the first lecture. Especially thank P.S. Prasad Garu, our former Advocate General, for supporting the association in organizing this program. Helping us in inviting Justice Navin Sinha Garu. Thank you. I request all the members of the bar to join IT in the corridors. Thank you all. At the 11th bar.